Welcome to everyone who's here this afternoon. My name is Christina Rodriguez. I'm the Dean of the Yale Law School, and I am honored and delighted. Thank you. I'm honored and delighted to welcome you all to the 2025-2026 James A. Thomas Lecture. This lecture is an event in the intellectual calendar of the law school each year, and it's in honor of Jim Thomas, the legendary Dean of Admissions, who from 1969 to 2004 ensured that we had a Yale Law School by admitting our student body. And he admitted generations of law students, including my own cohort. And so it's a wonderful honor to be able to introduce this lecture. Today we have in the audience, and I want to acknowledge his wife, Deborah Thomas, and his son, Michael Thomas. Thank you for being here. Before I introduce our lecturer, I would like to note that there should be no photos, no videos, and no recordings. Thank you for observing that rule. We're honored to be joined by Associate Justice Ketanji Brown-Jackson today to deliver remarks entitled Equity and Exigency, a first principles solution for the Supreme Court's emergency docket. Confirmed by the Senate on April 7th, 2022, Ketanji Brown-Jackson is the 116th Justice of the Supreme Court of the United States. On the South Lawn of the White House the day after her confirmation, flanked by the President and the Vice President, she recounted her own story, and drawing from Maya Angelou said, "The path was cleared for me so that I might rise to this occasion." In fact, Justice Jackson has been forging her path with determination from the very beginning. When Justice Jackson was just 7 years old, her mother encouraged her to participate in their hometown's public speaking competition in the Miami-Dade County Youth Fair and Exposition. A 7-year-old Justice Jackson recited lines from Margaret Walker's poem entitled "For My People," a reflection on Black people's long march to freedom in American history. On the stage, at age 7, she proclaimed, "Let a new earth rise, let another world be born, let a people loving freedom come to growth." Of course, she won the competition. She later went on to be a star of her high school speech and debate team at Miami's Palmetto Senior High. And because I roamed around the high school debate circuit at around the same time, I happened to know that Miami Palmetto was a juggernaut. And so it was no small feat for her to lead that team. She has said without hesitation that it was the one activity that best prepared her for her success in law and life, where she learned how to reason and how to write, how to learn despite obstacles, how to work and strive for excellence, believing anything was possible. And it was on a debate tournament when she first encountered Harvard, where she would later attend college and then law school. And she has reportedly said in interviews after walking around the campus as a teenager that she thought, well, this looks like a decent school. And we here at Yale agree. So Justice Jackson's professional path is well known now that she has ascended to the Supreme Court. After Harvard Law School, she was a law clerk for Justice Patty Saris of the United States District Court for the District of Massachusetts and for Judge Bruce Selya of the First Circuit. And then for Justice Stephen Breyer, the justice she would later replace in 2022. She credits Justice Breyer with constantly reminding her of the singular importance of the rule of law. In her early career, she spent time in private practice. She served as counsel on the U.S. Sentencing Commission. She served as a federal public defender. Of her experiences in these domains, Justice Jackson has said, "I came to believe that pursuing fairness and how our government exercises its power over citizens who breach its commandments is essential to constraining government overreach, which is, in turn, necessary to sustaining our very democracy." She has lived out these commitments to the rule of law and equal justice under law throughout her judicial service, to ensuring that the law applies throughout our system to which everyone is bound and protected by the law, no exceptions. Today, we will hear about some of the substance of this commitment to the rule of law in her lecture on the Supreme Court's management of its emergency docket, of which she has been a sharp critic in her writings as a justice. Through this, she will give us a window into her understanding of the court's role in our constitutional democracy and in this historical moment. Justice Jackson's career embodies many of the same values that animate this institution, a rigorous, scholarly, analytical bent, a dedication to public service, and a steadfast commitment to the rule of law. So please join me in welcoming the 116th Associate Justice of the United States Supreme Court, Ketanji Brown Jackson.
Thank you. Thank you. Thank you all. You may be seated. Thank you very much for inviting me. Thank you for that wonderful and generous introduction. I am delighted to have this chance to provide my thoughts about a topic that has recently burst into the public zeitgeist, generating a substantial amount of controversy. You've no doubt heard of the aspect of the Supreme Court's practice that critics sometimes refer to as the shadow docket. But even if you're not familiar with the part of the docket that involves the use of truncated procedures to evaluate emergency requests for interim relief, I would bet that you are aware of the extremely consequential decisions the court has made recently in cases that come to us in this posture. There are many examples, but the point of this speech is to focus on the Supreme Court's emergency docket, my preferred term, as a whole, as a procedural mechanism, rather than any particular case. And I would like to start by saying that I've come neither to praise the emergency docket nor to bury it. Instead, I want to provide what I hope will be a clarifying perspective that focuses on, first, what the emergency docket is, that is, what it's designed to do and its traditional function within the overall appellate framework. Second, how, in my view, the court's use of that docket has become problematic. And third, what we can do to return the emergency docket to its original auxiliary role in the judicial process. Okay, so let's start by defining the Supreme Court's emergency docket. At the most basic level, the emergency docket is one of several ways that the court exercises its power to adjudicate cases and controversies under Article 3 of the Constitution. When I was a law clerk for Justice Breyer 27 years ago now, I remember conceptualizing the court's case-related responsibilities as basically falling into three buckets. First, the merits rulings. Those are the cases in which the court has decided to grant certiorari review and hold oral argument. Second, it's decisions about which cases will get certiorari review. And third, applications for emergency relief. Being a Supreme Court law clerk is a little like being one of those jugglers in a circus with the three long poles that have plates spinning on top. Your job is not to let anything drop. In this speech, I am focused on the third plate, applications for emergency relief, which is a vessel that actually encompasses a wide variety of requests. But the kinds of requests that have generated the most attention lately are those in which the court is asked to either stay an injunction that a lower court has issued or issue an injunction in the first instance. It is those requests that I'm homing in on today, and I think the most effective way to explain them is by means of an analogy. So here goes. Imagine two next-door neighbors, both of whom claim ownership of a backyard shed that appears to straddle the line between their two properties. They've been fighting about who owns that shed for years, but the battle escalates when one of them, let's call him neighbor A, decides that he wants to grow a vegetable garden on that plot and schedules a demolition team to come remove the shed. From one porch to another, neighbor A says casually to neighbor B, "Oh, by the way, I'm starting a garden, so I've called some folks who will be here next Thursday to take down that shed." Lifting his eyebrows, neighbor B grits his teeth and angrily responds, "I'll see you in court." Now, I realize that this is not the kind of dispute that would ordinarily make its way to federal court for jurisdictional reasons, but please go with it. I need a simple analogy. So neighbor B files his complaint a few days later, and in it, he makes a legal claim, namely, that the shed is on his property, and thus he owns it. Because it's mine, he says, I'm asking the court for a declaration of ownership. Also, and this is the important part for present purposes, because I know that it will take a while for the court to resolve this legal claim, I'm asking the court to issue a preliminary injunction that prevents neighbor A from tearing down the shed while my claims are pending in court. All right, so you see what has happened. When neighbor B comes to court, he makes two requests. First, Judge, please tell everyone the shed is mine. And second, please prevent neighbor A from tearing down the shed while you're evaluating my ownership claim. Those are two distinct requests, and from the court's perspective, they raise completely different issues. The first is a matter of law. That is, what does the law hold about which neighbor, A or B, is the rightful owner of the shed? The second is a matter of equity. What is the fairest way to proceed in the interim while the merits of neighbor B's legal claims are being litigated? Should the shed be torn down, which would destroy neighbor B's claims but allow neighbor A to move forward with his garden? Or should the shed be left standing, which would preserve neighbor B's legal claim but would impose significant delay and perhaps additional costs on neighbor A? With his request for a preliminary injunction, neighbor B is essentially asking the court to take into account real-world facts about how both parties might be impacted on the ground before the case is resolved. Now, as many of you in this room know quite well, the district court will look at the applicable law and gather relevant facts to decide neighbor B's ownership claim as a matter of law. Less well known and not as easily understood are the very different standards that govern the district court's resolution of neighbor B's request for a preliminary injunction. In a case called Winter versus Natural Resources Defense Council, the Supreme Court explained that a preliminary injunction is an extraordinary remedy never awarded as of right. The court also required courts to find four things to issue a preliminary injunction: that the requester is likely to succeed on the merits, that he's likely to suffer irreparable harm in the absence of preliminary relief, that the balance of the equities tips in his favor, and that the injunction is in the public's interest. You will hear me say this quite a bit, and I cannot emphasize enough that a court uses its equitable authority to make this determination, and the preliminary injunction decision is thus fundamentally different from deciding the merits of the legal claim. To determine whether to issue an injunction or not, the court is looking at facts on the ground and deciding what should happen in the real world in the interim while the legal claims are being decided. Okay, if you're still following me, let's suppose that the district court issues the preliminary injunction that neighbor B requests, thus preventing the shed from being raised while the legal claim is under consideration. Neighbor A is disappointed, but of course, he could accept this and promptly turn his attention to mounting his merits defense. He still has every opportunity to prove that he owns the shed, and he may very well be right about that in the end. But in the hypothetical I'm building, neighbor A is impatient. He's upset because he's already scheduled the demolition crew and really wants to move forward with his garden. His beef is not that he's going to lose the case, it's that he doesn't want to have to wait for his victory. So rather than accepting this temporary pause to his gardening plan or even asking the court for an expedited ruling, neighbor A goes to the Court of Appeals asking for review of the preliminary injunction. And on top of that, he also asks for a stay of that preliminary injunction. A stay lifts the injunction. So if neighbor A gets the stay, it would basically resolve the case because it would allow the shed to be torn down while the appeal is pending. This is where I need you to start paying attention, because neighbor A's stay request is the kind of ask that is at the heart of many of the controversial opinions that the Supreme Court has recently issued. To repeat, granting a stay would suspend the preliminary injunction and allow the demolition crew to proceed apace, while denying the stay request would keep the injunction in place. The shed would continue to exist and the parties would continue litigating about its ownership. Thus, just like the district court before it, the Court of Appeals now has two determinations to make. One as to the merits of neighbor A's appeal, and the other as to whether or not to stay the preliminary injunction pending the results of that appeal. A federal appellate court typically gets its power to issue a stay from a statute called the All Writs Act, which authorizes federal courts to, quote, issue all writs necessary and appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law, end quote. That statute gives the appellate court equitable discretion to determine whether or not to lift a ruling that a lower court has made. And the courts of appeals often use this authority to assure that nothing happens in the real world to extinguish the eventual appeal. The Supreme Court has also long recognized that the authority to grant stays has historically been justified by the perceived need to prevent irreparable injury to the parties or the public pending review. So traditionally, the crux of a stay inquiry is determining what would be fair and right while the litigation is pending. The Supreme Court standardized that stay determination in a case called Inken versus Holder, requiring courts of appeals to determine 4 factors: whether the stay applicant has made a strong showing that he's likely to succeed on the merits, whether the applicant will be irreparably injured absent a stay, whether issuance of the stay will substantially injure the other parties interested in the proceeding, and where the public interest lies. Now, if those factors sound familiar, they should. They are essentially the same ones that courts use to determine whether a preliminary injunction should issue in the first place. Okay, for present purposes, let's assume that the Court of Appeals does not issue the stay that neighbor A requests because, for example, neighbor B would obviously suffer irreparable harm if the shed is torn down before his lawsuit is resolved, and neighbor A hasn't shown that he would suffer any harm if the stay is imposed. That is, he hasn't offered any reason why he needs to build this garden right now. So the stay request is denied, the injunction remains in place, and one might think that would be the end of the story. But wait, there's more. Under Supreme Court Rule 22, if a court of appeals denies a stay, the aggrieved party, neighbor A in my hypothetical, can go immediately to the Supreme Court and ask it to grant the stay. Please don't miss the fact that when neighbor A goes to the Supreme Court under this rule, significant portions of the dispute are still pending in the lower courts. The district court still has the merits question of who owns the shed. The Court of Appeals still has the appeal of the district court's grant of preliminary injunction preventing neighbor A from tearing down the shed while the merits of the claims are being resolved. But neighbor A is undaunted. With Rule 22 in hand, he asks the Supreme Court of the United States to enter this same fray. Let me pause here for a moment to provide the nuts and bolts of what happens internally when a stay request is filed with the Supreme Court. Parties who want to stay or get an injunction from the court file an application requesting that relief. The applicant typically argues that the stay or injunction is urgent because they are experiencing harm in the real world. The application is addressed to a single justice, the one who has been assigned as a circuit justice for the region from which the matter originates. And the circuit justice can either handle the application within her chambers. Yes, each justice has the power to issue stays, or refer the application to the full court for consideration. If the application is referred to the entire court, a truncated decision process follows, and a cursory order usually results. It's not uncommon for the Supreme Court to rule within weeks of receiving the referral, and to enter a one-line order that simply says, the application for a stay presented to Justice X and by her referred to the court is granted or denied. There is no requirement or expectation that the parties will engage in a full round of briefing, and the court ordinarily does not schedule oral arguments. To decide the stay question, the court applies the same 4 in-kin factors I've described, and it also sometimes considers whether it's likely that certiorari review would be granted if the case had been brought to the court in the ordinary course. Okay, so those are the basics of how a stay request gets to the justices' inboxes. Here are 3 more background considerations before I discuss how the court's review of stay requests has been operating recently and why I think it's problematic and the solutions that I would offer to try to get it back on track. First, you might be surprised to know that the nature of stay requests that have predominated on the emergency docket has changed over recent years. When I clerked in October term 1999, the overwhelming majority of stay requests were in capital cases. In fact, requests for stays of execution were so prevalent that we equated them with the emergency docket itself. The law clerks colloquially referred to the staff attorney who monitored all emergency docket filings as, quote unquote, the death clerk. A justice might occasionally receive a stay request in a non-capital case, but the bread and butter of the emergency docket were matters of life and death, as it was for most of the court's history. Fast forward to October term 2024. By that year, the court decided many more non-capital emergency applications than capital case stay requests, and the number of non-capital applications that were referred to the full court was 5 times greater than what it had been 2.5 decades before. There has been a clear shift in the kinds of emergency applications that this court is entertaining, and I think that's significant for myriad reasons, one of which is that it makes eminent sense for stays of execution to be addressed by the court on an emergency basis. Those requests are quintessentially emergencies. A capital defendant seeking a stay of his impending execution cannot wait for his claims to be handled by the Supreme Court in the ordinary course. Moreover, as far as the stay factors are concerned, irreparable harm to the capital defendant is a given. So much of the factors in the focus in the stay inquiry in capital cases is on the defendant's merits arguments. The factors play out differently in other kinds of cases because they rationally involve an assessment of the concrete harms the applicants say warrant interim relief. The second thing I would like for you to be aware of is that not all stay requests are the same, and it is critical to understand how the underlying facts, and thus the basis for granting or denying a stay, can differ. Consider once again my feuding neighbor analogy. Neighbor B ran to court and successfully secured a preliminary injunction to keep the shed from being torn down while his claims were pending. Under those circumstances, the stay question was whether to lift that injunction and allow the shed to be destroyed. But imagine a different set of facts. Instead of neighbor B, neighbor A goes to court, requesting a declaratory judgment that he is the owner of the shed and asking for a preliminary injunction that allows him to remove the shed at his discretion. If the district court grants neighbor A that interim relief, the stay request would be made on appeal by neighbor B, who would want that injunction lifted in order to keep the shed intact. Notice that when the district court's preliminary injunction is the impetus for the shed's destruction, granting the stay on appeal would preserve the status quo. But the opposite result happens if, as in my original hypo, the district court enjoins destruction of the shed. Then issuing the stay on appeal upsets the status quo. Knowing the procedural history of a stay request is the key to understanding how the equities play out. Third, and finally for this background portion, in my experience, the equities are rarely a wash. Recall that the whole point of the underlying merits proceeding, which is still pending in the district court, is to determine who owns the shed as a matter of law. With respect to the separate request for interim relief, the focus is quite different. The court must make an equitable determination about where things should stand in the interim, should the shed exist or not, while the merits claims are being litigated. Thus, what the courts are looking for when deciding what the interim status should be is evidence and argument about any concrete real-world injuries that might result from the delay caused by the course of the litigation over the ownership issue. The court is a neutral adjudicator. It does not know who has the better legal argument walking in the door, but it does know that a fully and fairly decided legal issue takes time. So, for equity's sake, the goal of the court's interim assessment is to minimize the harms that can occur while the underlying legal claim is being evaluated. In my hypothetical, neighbor B would have a strong harm-based argument that tearing down the shed while the case is being litigated qualifies as an irreparable harm, and that his harm outweighs the harm to neighbor A if the scheduled demolition has to be postponed. Neighbor A might also have a harm-based argument too, if, for example, he were able to demonstrate that a concrete injury would result from his not being able to plant the seeds right now as he had hoped. Like, say, he's hosting a party in a couple of months and he needs the resulting harvest. But neighbor A cannot just say, I'm harmed by this injunction because I'm going to win on the merits since I'm the actual owner of the shed. Sorting through the real-world facts and sussing out the harm-based allegations is what the interim relief determination is all about. And the actual balance usually tips in one direction or the other. All right, I've given you a lot of background, and I'm mindful of the time, so here I go. Let's turn to how the Supreme Court has been handling stay requests in non-capital emergency cases lately, and why I think the current practice is so problematic. The first thing I want to highlight in this regard is the relatively unique nature of the Supreme Court's jurisdiction, and in particular, the fact that with the exception of a handful of original matters, the Supreme Court has an enormous amount of discretion over the cases it hears. Its jurisdiction is highly discretionary. You might think, well, people are filing stay applications, so surely the court has to rule on them. But actually, that is not the case, at least not as to the merits of those stay requests. Unlike the lower courts, which are required to make substantive determinations with respect to any request, claim, or issue brought to them, the Supreme Court can decide not to decide, and it does so all the time. Certiorari is a perfect example. When a party loses, they file a petition that essentially pitches to the Supreme Court reasons why it should hear the case. There's no expectation that the court will take up the matter, and we routinely decide not to do so for things that have nothing to do with our view or of the correctness of the lower court's ruling. Stay requests are substantially similar. They are discretionary asks that the court could absolutely treat in that same fashion. When a party to litigation that is pending in the lower court seeks a stay of an interim order the lower court has issued, think neighbor A, the Supreme Court could conclude, in effect, that there are already enough irons in this fire, and unless there is a real need to add another one, we will leave it to the lower courts to make the interim status determination. Sometimes discretion is the better part of valor. And indeed, there is a long track record of justices opting out of making stay decisions in precisely this manner. Historically, it happened most often when a single circuit justice would deny a stay request because they saw no urgent need for the court to get involved. Justice Scalia was known for doing this. For example, he once wrote that when 2 lower courts had already denied a stay request, the applicant bore, quote, an especially heavy burden, end quote, to secure one from the Supreme Court. But in recent years, the Supreme Court has taken a decidedly different approach to addressing emergency stay applications. It has been noticeably less restrained, especially with respect to pending cases that involve controversial matters. When I clerked, the justices were aware of the high-profile, hot-button issues that were moving through the lower courts, but in my experience, they generally hoped that those cases would stay away from the Supreme Court as long as possible. I think the justices understood that very little good comes from taking an institution that is supposed to be operating outside of the political realm and routinely steering it into the fray. There is value in avoiding having the court continually touching the third rail of every divisive policy issue in American life. Back then, the justices also revered the work of their lower court brethren. They understood how important it was to have firmly established factual records and fully developed lower courts' opinions before the Supreme Court sat down to do its work. The High Court is, after all, a court of final review, not first view, as we are fond of saying. And of course, the Supreme Court is not and does not know everything. So back then, the justices humbly waited until the facts were established and the lower courts had fully and fairly assessed the law before making pronouncements. It was only in exigent circumstances, actual emergencies, that they felt the need to intervene in pending cases, much less use their extraordinary power to revise a lower court's fact-bound determinations about the most equitable interim status. Things are different now. Today, the court routinely opts to enter the fray, and it fails to acknowledge the harms that follow when the Supreme Court of the United States consistently and casually divests the lower courts of their equitable authority. And this is happening in the most high-profile cases. I'm talking now specifically about legal challenges to executive orders and administrative actions. The court's modern stance as it relates to these kinds of stay requests generally plays out as follows. The federal government will announce a dramatic change to an existing government policy or program, one that on its face will have enormous real-world impacts when it's implemented. Consider, for example, the Department of Homeland Security's March 2025 termination of the lawful parole status of nearly 500,000 migrants from conflict-ridden countries who had been granted temporary permission to live and work in the United States. In the old days, the administration might have set the effective date of this kind of policy change off some months in the future. But recently, the government has seen fit to make many of its sweeping policy changes effective immediately. So naturally, those who are affected run to federal court, trying to stop the immediate implementation of the new policy. And just like my hypothetical judge adjudicating the dispute between the feuding neighbors, the district court then has to determine both the lawfulness of that policy change and, sometimes within hours, whether to enjoin the implementation of that policy until its lawfulness can be determined. The district court decides asks, what is likely to happen if the policy change is halted versus if it's allowed to take immediate effect? And this inquiry into real-world effects lies at the heart of the judge's duty to balance the equities and set the interim status so as to minimize the harms to all concerned. If you take away one thing from this speech, let it be this: that the preliminary injunction and stay determinations are about the fairness of the immediate implementation of a challenged action. Thus, the proper evaluation strives to identify and balance out the relative harms. Yet, somehow, in case after case, the modern Supreme Court has largely ignored this, focusing instead mostly on the merits, and thereby facilitating real harm to real people and their interim interests. In short, the Supreme Court's predominantly merits-focused analysis has led it to consistently ignore or at least undervalue real-world harms when resolving stay requests on our emergency docket. Let me turn now briefly to the specific problems that I think the court's stay practices have caused. And there are many, but here I will quickly highlight three that I think are particularly significant. The first is the corrosive effect of the Supreme Court's stay-related interventions on standard litigation and appeals practices, especially when the court purports to grant a stay on the basis of the applicant's likelihood of success on the merits. Our federal judicial system is structured around a fairly simple concept. There are tiered layers of review, and each court exercises jurisdiction in seriatim, one court at a time. A corollary to this is that the circumstances under which the same case can be considered by more than one court simultaneously are supposed to be few and far between. Indeed, we have a complicated set of rules that establish exactly when a party with a case pending in one court can obtain interlocutory review. And for the most part, courts of appeals simply have to wait for the trial courts to finish before exercising their power to consider issues in the case. This means that stay requests are an anomaly. They really do show up as exceptions to the usual order of operations. And like many exceptions, there is a risk that they will swallow the rule. You can see this by thinking back to neighbors A and B. If the Supreme Court swoops in and gives neighbor A a stay based on its conclusion that he is, in fact, the likely owner of the shed, what then remains of the underlying ownership dispute? I mean, really, what is left for the lower courts to do? I suppose the district court could carry on reviewing the evidence and listening to the arguments about an issue that the Supreme Court has already basically decided. But it's hard to fathom that our justice system would countenance preordained outcomes following from zombie proceedings in this way. When based on the merits, Supreme Court stays effectively take all of the wind out of the sails of the pending lower court proceedings, which is a terrible result, and even more important, it is not how our justice system was designed to work. Nor is it conceivable that, as the court recently suggested, its rulings on stay applications should, quote, inform how a lower court should exercise its equitable discretion in like cases, end quote. Does that mean that lower courts should forget what equity requires of them and not make nuanced assessments of the particular harm-related facts that arise in an individual case? The court has now puzzlingly suggested that equitable fairness assessments can be precedential, which, for the reasons I've explained, is not and cannot be the case. So the court has left confusion in its wake, and it offers little guidance because it ordinarily does not spell out the circumstances giving rise to its own equities evaluation, making it incredibly difficult for lower courts to understand which facts were important to the stay determination and thus identify like cases. But even that debate obscures a more fundamental issue. It simply does not make sense for the Supreme Court to create lock-in effects with respect to legal issues while deciding emergency stay applications. As I noted before, the point of an emergency application is just to avoid the real-world harms that can come from litigation delay. Having lock-in effects about who will win on the merits is not the mission, nor can it be, because, as I explained earlier, not all stay decisions are the same. Consequently, it is one thing for the Supreme Court to entertain a stay application early in a case's life cycle and publish its back-of-the-envelope first blush impressions of the merits of the legal issue. It is quite another for the court to then insist that those scratch paper musings be applied by other courts in other cases, stymieing the full deliberative process. Thus, there is a serious concern that the Supreme Court's modern stay practices are having an enormously disruptive and potentially corrosive effect on the functioning of the federal judiciary's usual decision-making process. The second concern is the potential for dilution of equal justice principles. The emergency docket is a procedural outlier that is operating in a system where the core objective is to ensure that all litigants are receiving equal treatment. Courts have a duty to provide equal justice under law, and achieving that goal happens largely by design. We have one Supreme Court that is the final arbiter of legal disputes that arise under federal law, and that court has standard procedures that apply across the board, regulating its decision-making. We also have a standard practice for obtaining Supreme Court review. An aggrieved party prepares a cert petition, files it timely, and waits in line for the court to address it. Thousands of petitions are filed in this fashion every term. There are certainly emergencies, and our system does need to have a mechanism that allows the court to address them. But if we are not careful, the emergency docket can and will become an end run around the standard review process, a special avenue that certain privileged litigants can utilize selectively. Think about that for a moment. Why is it that neighbor A should get a fast pass to having the Supreme Court of the United States opine on the merits of his ownership dispute when so many other parties are queued up and waiting patiently for the court's attention? Is there a reason why he warrants this special treatment? Why can't neighbors A and B finish litigating in the lower courts and then come stand in line like everybody else? My worry is that neighbor A has spotted a strategic advantage. Through the emergency docket, he can get 2 bites at the apple. If the court denies the stay he wants, he'll just go back down, litigate below, and return here in the ordinary course. For savvy parties who have the money and the wherewithal, there really is no disincentive to doing that. Savvy parties are also more likely to know about this shortcut to a potential early resolution and can seek to position their claims and arguments accordingly. As one of my colleagues recently suggested in an opinion, while other litigants have to wait in line, some frequent emergency docket filers have the court on speed dial. With this unfettered approach to emergency stay applications, the court appears to have opened up more than one lane to get to essentially the same result, having the final arbiter rule on the merits of the underlying claims. And the alternative path is a much easier row to hoe, both for the litigants and for the court, since there are no procedural requirements ensuring regularity or transparency with respect to rulings on the emergency docket. In my view, then, having a so-called interim relief docket that enables sophisticated parties to vet live legal claims that are proceeding in the lower courts is a threat to equal justice under law. For some parties, the court now offers a merits ruling preview. They can skip to the front of the line, and the court will take a peek at the merits and provide its take before the lower courts have acted. But of course, this special opportunity will not and cannot be afforded in an even-handed fashion. So instead of equal justice under law, the likely outcome is a patently inequitable procedural hybrid. The standard, slow, and deliberate review process for some claimants operating alongside a fast lane to victory for others. Third and finally, I am very troubled by the institutional costs that the Supreme Court's current stay practices impose on the institution in terms of its relationships with the lower courts and the American people. They are substantial. To start, having a docket that allows the court to routinely interfere with lower court cases while they are in progress disrespects the lower court's authority and withholds the deference appellate courts have traditionally provided regarding fact-bound matters that are within a trial court's expertise. In addition, the court is withholding its own work product by issuing summary orders, further undermining the public's confidence in our judicial colleagues. A one-line stay grant that overturns a lower court's contrary conclusion suggests that the judgment call was so easy that no deliberation or explanation is required. And that suggestion casts aspersions on the tedious work that our colleagues have done to carefully parse the evidence, weigh the various factors, and exercise their considerable equitable discretion. Summary orders on the emergency docket are also costly in terms of the court's own relationship with the public. The Supreme Court's power comes from its reasoning, so it really does need to inform the public as to why it has decided to chart a particular course. Issuing important decisions in such a cursory manner disrespects not only the people whose lives are upended by its rulings, but also the public that has given it trust and authority. And then there is the fact that significant real-world harms can follow Supreme Court rulings. And when our orders don't acknowledge that reality, they seem oblivious and thus ring hollow. Similarly, given the real-world facts that a stay request asks the court to consider, the court's stay decisions can, at times, come across utterly irrational. We cannot expect the public to have faith in our judicial system if, without clear explanation, we consistently green-light harmful acts that do real damage to litigating plaintiffs without a court decision fully and fairly determining the lawfulness of that challenged conduct on the merits. A litigant can do all that our justice system requires to promptly bring the case to court, to name the law at issue, to gather the evidence needed to persuade a judge or jury that the challenged conduct violates the law. And still, if our court permits the harm to happen in the interim, that person gets no remedy. And our legal system, our legal process, is reasonably perceived to be a farce. That outcome is not only unfortunate, it is the archetype of injustice. And indeed, avoiding injury is precisely why the equitable power and interim injunctive relief exist in the first place. In the few minutes that remain, I bring the good news. Having identified the problems, I am confident that my court can easily avoid them by returning to and relying on first principles. Here's how. When the court gets a stay request, we should remember, first of all, that there is an underlying lawsuit, the entire point of which is to resolve the merits of the legal claim. The temporary injunction and stay proceedings are merely auxiliary. They are not supposed to be the main event. Similarly, we should recall that lower courts have a substantial role to play in the fair and full adjudication of the primary dispute. And they should generally be allowed to carry out their duties without our interference. We should also understand that equitable discretion is, we should also understand what equitable discretion is, and importantly, how it differs from law. Equity is rooted in fundamental fairness, which is the goal of interim relief. Wisely exercising equitable discretion involves evaluating facts, including assessing the credibility of witnesses and weighing disparate assertions, things that appellate courts really are not well equipped to do. That is to say, as a matter of first principles, we should have some humility about stay determinations. And although it will be hard, we can patiently await our turn to exercise our discretion, as respect for the judicial process requires. Litigating parties need to be encouraged to make their case at every stage of the litigation, not to run back and forth to the courts of appeals anytime the lower court does something they don't like. Yes, stay processes exist, but they are inefficient and distracting. And as I've explained, absent an emergency, they are ultimately incompatible with how our system works best. The most reliable outcomes happen when the parties focus on developing the factual record, crafting their best legal arguments, and trying to persuade the lower courts to rule in their favor before seeking our review. And ultimately, the justices need to return to acting like the final court of review that the Supreme Court holds itself out to be. This is not a novel concept. Our predecessors called it judicial restraint. We don't hear about that much anymore. I think it's time to bring it back. So here is a specific proposal. It has two parts, both of which are relatively straightforward. First, when someone asks the Supreme Court for a stay, we should impose a threshold criterion that would allow us to neutrally ascertain whether or not to intervene. Having this initial hurdle is both a first principles concern, restoring restraint and discretion, and also a resources issue. The Supreme Court cannot involve itself in real-time supervision and correction of every lower court exercise of equitable discretion. We simply do not have the resources to do that. So, if the court is going to step in sometimes, we need to know when. We need a threshold criteria that is neutral and consistently applied. My proffer is, as you've guessed it, exigency, as derived from the traditional purpose of the emergency docket. Exigency not only rationally justifies our early intervention, it also helpfully ensures that we rarely exercise this power. And it reasonably focuses on facts. We'd be looking at the outset for a fact-based reason to step into this matter now. That the applicant is a high-level government official or that the case presents important issues is simply not enough. Rather, any and all stay applicants would need to show something to us. They would need to show that something harmful will happen in the real world absent the court's intervention, thereby demonstrating urgency. So, hypothetically, when neighbor A requests a stay, the court would start by asking a very simple question. What are you doing here? That is, what is so urgent that all 9 justices and their staffs have to put down what we're working on now and turn to address your case? The right answer is not, well, the district court is making a mistake, or I'm going to win on the merits, or even, I really want to build this garden now before the case is over. Neighbor A needs facts on the ground that indicate impending harm or some other reason why this simply cannot wait until the lower courts are done. The second prong of my proposal involves restoring the role of equity in cases that are filed on our emergency docket. Once an applicant has established exigency, in my view, the only remaining question is whether the equities favor the requested intervention. And that question is best resolved by considering the equities first and turning to the merits only later as a check if needed. So how would that work? In my feuding neighbor hypo, assume we are considering the substance of neighbor A's stay application. He's cleared the exigency hurdle. We would set aside the merits question of who owns the shed and start by evaluating who has the better argument about the intervening harms if the shed is torn down or left standing. By doing this, it would be quickly apparent that the district court reasonably assessed the relative harms when concluding that the shed should be left standing for the duration of the case, and if the Court of Appeals agreed, we would require neighbor A to bear an especially heavy burden of persuading us that the harm balance turns out differently. Imposing that burden would likely be the end of the stay inquiry, but I do think that there could be circumstances in which an assessment of the underlying merits might be helpful on the back end as an additional input for the equities analysis. Capital cases are a good example of this. There's obvious exigency, and very real harm will befall the defendant if the stay of execution is denied, arguably more harm than would be suffered by the state if the stay is granted. But often, the legal claims that capital defendants raise have little to no chance of succeeding based on established law. So while the harm-based equities would favor granting the requested stay, the minimal likelihood of a capital defendant's eventual success means that, in fairness, the state should probably not be made to wait until all those non-meritorious legal claims have been fully vetted before being allowed to carry out the authorized punishment. When we do the stay analysis in this way, equities balancing first and then asking whether the underlying legal claims are plausible, the likelihood of success factor becomes part and parcel of the overall equities assessment in a manner that makes perfect sense given the auxiliary role of the stay determination. My feuding neighbors example bears this out. Suppose neighbor A has an urgent need to get the seeds in the ground right now. And to sustain his stay request, he also produces a copy of the original plat that plainly shows that the shed, which his great-great-grandmother built with her bare hands, is sitting on his property. Meanwhile, neighbor B is facing irreparable harm if the shed he claims to own is dismantled. But if neighbor B has no evidence to support his underlying ownership claim, it's implausible that he will ultimately succeed on the merits. So, on balance, the injunction seems inequitable, and neighbor A's stay request should probably be granted. To summarize and almost close, I propose that the equities be evaluated first, and that the merits enter only as a plausibility check after the relative harms have been assessed, to ensure that a plaintiff who does not have a realistic chance of winning cannot use the legal process to throw sand in the gears despite being potentially subjected to intervening harm. If a claimant does have some chance of winning on the merits, equity usually would not permit his claim to be mooted out by a harmful act that interim injunctive relief can easily prevent. Litigants should not have to suffer injury while the courts are considering their legal claims if the equities favor them and there's a chance that they can win their case. The touchstone of equity is fairness. And in my view, the Supreme Court's stay practices should be designed accordingly. So that's it. I hope that you have found this discussion edifying and that it has given you a better sense of the stay requests that the Supreme Court receives on its emergency docket, how the court is handling them, and why I think our modern methods are not serving the court or our country well. I hope it's also clear why I adamantly reject any effort to normalize a process whereby the Supreme Court actively superintends matters that are pending in the lower courts. There is no such thing as an interim docket. Rather, we have an appellate review process with an equitable exception that can sometimes warrant the Supreme Court's early intervention, but only when exigent circumstances require that. I feel strongly that we need to stick with that history and tradition. I don't pretend to have all the answers, but I would like to be a catalyst for change. My hope is that this speech opens up a conversation and that you and all of us will carefully examine the operation of the Supreme Court's emergency docket and suggest reforms with an eye toward ensuring equal justice under law. Thank you.
Thank you so much, Justice Jackson, for spending that time with us. You've been saying some of these things in your writings from the bench, but it's an extraordinary opportunity for us to get to hear you spell them out with such rigor and such passion about the integrity of our system.
Well, thank you very much for this extraordinary opportunity to do that.
So we have about 20 to 25 minutes for some questions. So
Great.
I thought I would ask you a few questions that follow the structure of your speech, and then maybe we can veer beyond that if we have the time. So you start out by describing the standards that apply when parties are seeking an injunction or a stay. And there are two that then become relevant to your proposal for reform. And so I want to understand each of those and how you're thinking about them a little bit better. But so let's start with the concept of harm.
Yes.
And that's where you really place the emphasis and figuring out what the real world harm is.
Yes.
So how do you evaluate real world harm? Because for those of us who are reading either the government's briefs in a lot of the cases that are coming through the emergency docket or the court's opinions, there's a concept of harm that the inability of the president to be able to utilize his power
Yes.
is itself a harm. That is a constitutional harm for a president not to be able to exercise his rightful power. What relevance does that have in the calculus of harm?
So, in the calculus of harm, as I understand it, and let me start by saying I was a district court judge for the longest period of my tenure, 7.5 years in the District of Columbia. And so I have had to respond to parties who run into court the day before some catastrophic event and ask for injunctive relief. And what you learn very quickly when you're in that position is that harm has to be evaluated relative to what is happening in a concrete way with respect to facts on the ground. Something like constitutional harm is too abstract to drive this kind of analysis. Why do I say that? Because constitutional harm is actually little more than a legal concept. And we have an underlying legal process that is supposed to be determining whether or not the president or whomever has violated the law. I'm trying to figure out an easier way of saying this. The President of the United States, although he may be, in this hypothetical that you've posed, harmed in an abstract way by not doing what he wants to do, he certainly isn't harmed if what he wants to do is illegal, right? He doesn't have the ability to do something unlawful. And the point of the merits proceeding is to determine whether the thing he wants to do is unlawful. So the interim relief proceeding really has to be about something else. And the something else is, are we going to allow him to do this thing that is being challenged, in the interim while we are evaluating whether or not that thing is lawful? And the only way to make that determination without having it just completely collapse into forecasting the merits is to focus on what is going to happen if he does this thing concretely in the real world versus not. And so, I appreciate that the government makes that kind of argument. But what I would be looking for as a district court judge is the government explaining to me the need for them to implement this policy right now in concrete ways, and therefore the harms that would befall the government or the public if they don't do it now. That's what the interim relief determination is really about.
So, in a sense, then, our system, the way that you envision it, has a very strong status quo bias, or ought to have a very strong status quo bias.
It has to. It has to, because the challenge is about the lawfulness of the change. So I don't understand how we can decide that without having a legal proceeding that tells us what the answer is. I mean, one of the most important parts of the speech, I think, is when I said the court does not know, walking in the door, whether or not the person who is making this claim has the better legal argument. The point is that it takes time to figure that out. We want our justice system to have judges look at evidence, research the law, go to the jury if that's necessary. That's part of the legal process. And all of that takes time. So I just can't abide a scenario in which we are somehow forecasting who's going to win on the merits without doing all of those things.
So it's very clarifying when you say that there's not an entitlement to do something illegal, essentially. And so the harm can arise from exercising a power that could be an illegal exercise of power.
How could you be harmed from being stopped from doing something you're not allowed to do?
So then,
I don't.
Yeah. So then that leads to the second question about what the likelihood of success on the merits element of the standard requires.
Yes.
And you're suggesting in your proposal that we look at the harms first, irrespective of the likelihood of success on the merits, and then entertain the possibility that the legal claims might be completely unfounded. So if I have that right, what allows a court in this interim position to say that the claims are completely unfounded?
Well, I mean, there are ways to quickly assess the plausibility of the claim. There's a difference between saying, I can tell you right now who's going to win this issue, and I can tell you right now that this particular claim has no chance. I mean, this is the point of bringing up the capital cases, that there are many times when people make claims that the Supreme Court has already foreclosed this issue. You can more quickly eliminate claims than you can evaluate and determine who's going to be the winner. And I actually think that if you read the Winter case and if you think about the way this works, that that's really what they meant when they said the likelihood of success on the merits. Mm-hmm. That it was really about, is this a possibility, not who is actually going to win. Because it can't work that way if you have an underlying merits proceeding that it's supposed to be figuring that out.
So then, in the second part of your speech, you talk about the way the Supreme Court has been handling these petitions and contrast the current practice with what you saw as a clerk 27 years ago and the way up until very recently we thought about the emergency docket. And your formulation of it was evocative. You talked about the court historically wanting to steer away from politically controversial decisions. But I would not describe what it's been doing for the last year as steering away from politically controversial decisions. And so what do you think accounts for the court's willingness to jump into these cases? Is it something particular about our moment, about the rise of presidential action over the last 2 to 3 administrations? Is it something about this particular court and its understanding of executive power? Or is it something about our politics more generally that is leading the court?
I don't know the answer to the why. I really don't. I mean, all I can say is I know it's different because I had the great good fortune of clerking. And I know you clerked at a few years after me, and my observation was, and I think the statistics bear this out, that we have scholars who are looking into these issues and who have confirmed that the court is doing more on the emergency docket now in non-capital cases than it used to. I don't know the answer as to why, but I do think that the court can control it. I disagree with some of my colleagues who have made public statements suggesting that, the court really has its hands tied or that this is a function of a lot more of these cases being filed or applications being filed. And part of my response is if you build it, they will come. Field of Dreams, for those of you who are old enough to remember that. If we signal or suggest our willingness to grant these, then of course we're going to get more of them. But even beyond that, it is not the case, and this was the part of my speech comparing stays to certiorari, it is not the case that the court has to decide the merits of a stay application. The court could absolutely filter and say we're only going to do certain things, and that was common back when we clerked. So I don't know what happened to that practice, but I prefer it to what we're doing now.
It's definitely worth emphasizing that these are discretionary decisions. And so there are choices being made even if the world around the court is accelerating these kinds of cases.
That is absolutely correct.
I think people would be interested in knowing whether you ever talk about this with your colleagues or if you're communicating through speeches like this and through your opinions. Is this something that people grapple with? Because
we are all, as justices, trying to do what we believe is in the best interest of the institution. And we have conversations both through our opinions, internally at times, and through our public speeches, as we all grapple with, what definitely is a significant change in practice and what we should be doing about it.
So I think that makes sense that everyone on the court wants to do what's best for the court and their understanding of the legal system. You have a particular view of how the system ought to be working, and that what the court is doing now is undermining its legitimacy. And I wonder if some of that understanding of the importance of the lower courts having their shot at it is born of your experience, 7 or 8 years on the district court. There's one other justice, Justice Sotomayor, who served on the district court, but for less time than you did. And what do you think that, it seems like you're trying to preserve the special role of the district courts in our system. What is it that you think that role is, and what are we losing that others aren't seeing?
Well, I think that the factual record is a very significant and important part of accurate and consistent and correct decision making. I think it is not, it shouldn't come as a surprise to any of the law school students here that facts are the foundation for ultimate legal determinations, and that you can have different legal determinations when there are different sets of facts. And so you need somebody at the beginning of a case who is going to make a determination about who is telling the truth, what is the credible set of circumstances here, what are the findings that we make. And traditionally, the courts of appeals were actually bound to a certain degree with respect to accepting those facts. There was deference that was given to the trial court's superior ability to ascertain what the facts are, because they're the ones who see the actual parties, who are sitting there when the witnesses are testifying. They are the ones who establish the factual record. And we lose a lot if we are not paying sufficient attention to that foundation. Because I think one of the things you lose at the appellate level is the ability to have very grounded understandings of what these rulings mean and what they're doing in the real world. I think it's very easy to get really abstract really quickly when you don't have a good sense of what you're talking about in terms of the facts of the case. And so those were like the given back in the day. You'd have a factual record, and even people who vehemently disagreed on the law would start from a common set of, this is what the facts are in this case. And so now, when we don't really give the lower court a chance to develop the factual record, to make its determination with respect to how it sees the law applying, and then serve as a court of review, which is what we are supposed to be doing, I think the system is not designed for a process that does not take into account the significance of the lower court's proceeding.
So I think I have a sense of what your answer to this question might be, but how do you react to those who say that the Supreme Court, and the appellate courts for that matter, need to intervene to stop rogue district courts from exercising too much power? And this critique was, I think, a more significant one before the Supreme Court shut down the nationwide injunction in the CASA decision, for which you dissented.
I thought our whole system was designed to stop district court judges from being the one to make the decision. I don't know what that means. The district court is not the final arbiter. So if they're rogue, it gets appealed and they get overturned. I don't know what.
So it's about time. It's about timing. It's about timing.
It is about timing. And to me, the very significant downsides of being premature, of having the courts of appeals jump in too early, dwarf any kind of concern somebody has about a rogue district court judge. You can easily, if you have one of these judges, ask the courts of appeals to expedite their review. You can get the whole case and get it right up to the Supreme Court in short order. So there's no need, in my view, to have the Supreme Court exercising, or even, courts of appeals jumping in early. Let the district court finish, and then the appeals courts go to work.
So I want to switch gears just a little bit, though it does relate to the way in which you're challenging what's happening on the court, and that is to ask you about your dissents in merits cases. You've written some notable dissents in merits cases: Students for Fair Admissions versus Harvard, the affirmative action case. You were a lone dissenter just recently in the conversion therapy case. What are you thinking when you write independently as a dissenter? What do you think the role of the dissenter is on the court? We see them as outstanding teaching tools, but I have a feeling that's not what you're thinking when you're writing.
Well, you wouldn't
dissent.
be surprised. No, first of all, I think that dissent is one of the most extraordinary aspects of the American legal tradition, that it is an embodiment of one of our core values, which is freedom of expression and tolerance of minority views. It's extraordinary that we have a system that allows for those who disagree to voice their disagreement in sometimes very strident ways. And so I think the court models, in a way, the kind of society we should want and have, that people who have different views can actually articulate them. And I take advantage of it. You know, you asked me what I'm thinking. I'm thinking I disagree. I disagree with what the majority has said. I feel like it's my obligation, if I disagree, to make clear why. I think I'm speaking to law school students. I'm speaking to future jurists. I'm speaking to the American people because, you know, as my colleagues, former colleague, Justice Ginsburg and Justice Scalia, they were big proponents of dissent and the significance and importance of laying down a marker that not all of us agreed on this issue. Here's an alternative view. And you were doing that in part for history and for the future, for history and the future, because you hope that at some point better, cooler heads will prevail and someone will agree with your view.
So you clearly have in mind the possibility of change. At the end of your lecture, you talked about calling for change or a call to action, and what you just said about dissents, not just making a note for history, which has its own value, but also laying down a marker for the future. So how do you imagine that change happening? Is your role only to suggest that it ought to happen, or do you see in your time on the court or in your lifetime the possibility for the sorts of changes you want to see in the way the court functions and in the substance of the law?
I am at core a very optimistic person, and I think you have to be in a set of circumstances where you think you see things that can be improved and you're doing the work to try to bring that to fruition. I have no idea what the timeline is or how it will ultimately play out, but I do feel very strongly in the cases that I dissent in. When I write something, I am trying to express what I think the right answer should be, and my hope is that in the future that will come to fruition at some point.
So since I have you here, I have a question that I've always wanted to ask a Supreme Court justice,
oh no.
Which is, when you say I dissent as opposed to I respectfully dissent, what do you mean by that?
Oh my goodness, what do I mean by that? You know, I mean, the tradition, the standard, as you know, is for the justices to say I respectfully dissent. And I think just like the justices' determinations to read their dissents or summaries of their dissents from the bench, when you have a particularly vigorous disagreement, when you are intending to signal that this case you think is very significant, at times justices will drop the respectfully. You know, we can't do a lot, but we can do little things like that.
So we're close to the end of our time, so I wanted to ask a question in a more personal register, but that also relates to some of what you've written as a justice. When you spoke on the South Lawn of the White House, when you were confirmed to the court, you said, "In my family, it took just one generation to go from segregation to the Supreme Court of the United States." And I think there's a lot in that statement, and I think some of that might be reflected in your dissent from the SFFA decision. What does that statement mean to you? What do you make of where you are and where the country is?
Well, the statement, I think, was intended to express my gratitude for being able to serve on the Supreme Court of the United States. When I answer similar questions, I often refer to Constance Baker Motley, who was the first African-American woman to be appointed as a federal judge in the 1960s. And she was also a civil rights lawyer. She worked with Thurgood Marshall. She was part of the team that conceived of the Brown versus the Board strategy. She was the first black woman to argue in the Supreme Court of the United States, and she argued something like 10 cases, and she won 9 of them. She was a genius, but she did not have a chance to serve because of the times in which she lived. And so I feel extraordinarily grateful for the opportunity to do this work, to serve the American people, to be in the arc of history that allows someone like me from my background whose parents were subjugated to segregation, to be able to sit as I do, listening to the claims, evaluating the law, and doing my best to serve. It's an extraordinary honor. It's very difficult. People ask me, isn't it hard? Isn't it hard to be on the court at this time? I mean, absolutely, but it is also such a privilege. And so that statement was meant to convey my gratitude.
It's lovely to hear you talk about Constance Baker Motley. As I mentioned to you before, you are now the subject of elementary school biography reports, and you are providing sources of inspiration to the next generation. What do you hope that inspiration will be or consist of?
Oh, geez. This is sort of the question that people ask me about, what do I want my legacy to be? And I say, I'm only 3 years on the court. I want to be known for being a good communicator. I think that if I can inspire young people to use their voices, no matter where they're from or in whatever capacity, that would be extraordinary. And I also would like to inspire people to work hard, to do the hard work, to understand that nothing in life comes easy, and that I left everything on the field. And if people can take away from my experience, she's always writing, she talks too much, she's doing all these things, it's because I know that we can only get better if we all put our shoulders to the grindstone. And I'm trying to inspire people to do that.
Well, we can very much see that you're leaving everything on the field. And we could not be more grateful that you shared this afternoon with us here at Yale.
Thank you. I'm delighted to be here. Thank you.